I'm going to be talking to Professor David Wright of the University of Calgary Faculty of Law about some comments that Federal Energy Minister Tim Hodgson made in the Senate last week that have a very interesting constitutional wrinkle when it comes to will there be support or not support for the proposed pipeline from Alberta to the West Coast. So welcome to the interview, Dave.
Hi, Markham. Nice to be with you.
This is a very, very thorny issue, and there's a lot of consternation in British Columbia, I can tell you, and we hear it coming from Alberta loud and clear. So let me just say, let me repeat for the viewers what the minister said in the Senate. So he said, to build the pipeline, you need support of the jurisdiction you build through, and you need the support of First Nations. The proponent, in this case, the province of Alberta, needs to attract that support if they want to build. That's something between the province of Alberta and the province of British Columbia. The issue here is that the settled law seems to be that the federal government has exclusive jurisdiction over interprovincial pipelines, and agreement from the province of BC and BC First Nations shouldn't be required at all.
Well, as you said, Markham, it is a thorny issue and it gets into real technical aspects of the law in a hurry. And within that technical area of the law, there are, I would say, still open legal questions. Those open legal questions are perhaps even more complicated now that we've got the new Building Canada Act. So, of course, that act came into force at the end of June of this year after an unprecedented rushed legislative process. And what we may be experiencing here is actually a byproduct of that rushed process. And so it was interesting to hear what the minister had to say. It seems like an attempt to keep the dialogue in the political and negotiation realm as opposed to into the realm of statutory interpretation or constitutional law. But just put briefly, there is a provision in the new Building Canada Act that says that if a project does fall within an area of exclusive provincial jurisdiction, then consent of that project is required. So the open legal question in the context of this brand new legislation is, what's the meaning of that provision? What's the meaning of if a project falls within areas of exclusive provincial jurisdiction? So and there's a constitutional law dimension to that we can get into.
Well, when I read this, because I had done the reporting back in 2016 to 2018 around the National Energy Board rulings and then the court challenges of those rulings by the city of Burnaby and the province of BC. And it seemed pretty clear at that time that it was a settled issue that when a pipeline crossed the border, provincial border, that it was up to the federal government to approve and then to regulate. And so when I read what was in the Building Canada Act, it seemed to be really just a repetition, a reiteration of what we already knew or what we already understood.
Yeah, I mean, certainly most of the act is not inconsistent with that lay of the constitutional law landscape. But what's a little bit complicated in this context is the following. You've got under the Constitution Act 1982, Section 91 that enumerates federal heads of power and Section 92 that enumerates provincial heads of power. And that's come up quite a number of times in recent contexts. And I know you and I have chatted about that with respect to, for example, federal carbon pricing and the Federal Impact Assessment Act. What's interesting when it comes to this specific type of project, and as I've written already, a lot of what the Building Canada Act means in practice is the specific projects at issue. So with this specific proposed project, nascent as it may be, an interprovincial pipeline, the Constitution and case law interpreting the Constitution is relatively clear that it's exclusive federal jurisdiction. But the question under the Building Canada Act, which of course is subordinate to the Constitution, it's just legislation, it's not a constitutional document. The question is, okay, we know we have exclusive federal jurisdiction, but is there also exclusive provincial jurisdiction? Because we know that as the constitutional law case law has evolved, we're in the era of cooperative federalism. So courts will interpret laws as not conflicting to the extent possible, up to a limit. And so, as you reported on, as we know from most recently, the Trans Mountain Pipeline litigation, a province and a municipality can legislate and regulate in relation to an interprovincial pipeline. That's fine. That's cooperative federalism, overlapping jurisdiction, but only up until the point that it frustrates the federal purpose. And so when you have Premier Eby, for example, saying consent is required, it's not, that's an open constitutional law question, but if you had to land on an answer today, the answer would probably be that consent is not required because the province cannot frustrate that federal purpose.
I want to use an illustration from Trans Mountain that just for our viewers so they can understand
Sure.
it. So the city of Burnaby had to reissue permits for a whole variety, hundreds of things, including some tree cutting, for example.
Yeah.
And they were the National Energy Board was Kinder Morgan, the proponent, complained to the National Energy Board that the city was dragging its feet, and the NEB looked into it and said, "Yes, they're dragging their feet. They're really dragging the puck here just to drag this out." And so they issued a ruling that said that the city can't do that because of paramountcy, which means that the federal legislation took precedence over the provincial or the municipal, and therefore it was frustrating the federal intent to build the pipeline. And that's kind of what you were talking about.
Yeah, that's right. And so that was the NEB ruling as it's in its kind of quasi-judicial function. That's consistent with established constitutional law. So I think you can take that as the lay of the legal landscape that then applies in this context. The complication here is that the Building Canada Act doesn't so much talk about the federal exclusive jurisdiction. It more tries to grant the province some type of, under some interpretations perhaps, exclusive jurisdiction under 5.1 sub 1 by requiring consent. So, and that's that open legal question. So if you're British Columbia in this context, you're reading 5.1 sub 1 and saying, well, we think that this pipeline falls within an area of exclusive jurisdiction. Even though it's also exclusively federal, we know that these can overlap. A strong counter argument to that is that the section 92 sub 10 sub A of the Constitution Act says that it's explicitly says this is not exclusive provincial jurisdiction. And as soon as you get to that point in your constitutional legal analysis, you're at the point where the provincial government need only be consulted and need not, and consent is not the standard in this context. And so that's again open legal question, but that's where the tea leaves are on this specific matter. And it's important to recognize that we're talking about an interprovincial pipeline. Section 5 sub 1.1 of the Building Canada Act is about all manner of projects that could come along as projects of national interest. But this particular type of project, an interprovincial pipeline, raises these specific issues. Other types of projects may not.
I wanted to come back to your mention of cooperative federalism because my understanding of that, David, is that in the past there have been, there are areas where the province has jurisdiction, the federal has jurisdiction, and the courts have said, you know what, in the interests of Canadians, the public interest, we need you to get along. We need you to cooperate. So cooperative federalism. And during the Trans Mountain debate, a number of legal scholars that I interviewed brought that up as the counter to paramountcy. They said, no, this is not an issue of paramountcy. It's an issue of cooperative federalism. That's the way we think the court should interpret it. But that they, in fact, lost that argument.
Yeah, I mean, you could think of it almost sequential. So the first line of argument is going to be, okay, we're in a cooperative federalism context. The case law and judicial analysis and analytical frameworks have evolved to default to that, but it only goes so far. So just in clear terms, what that means is through cooperative federalism, the court is interpreting both sets of laws, federal and provincial, as not conflicting to their logical extension possible. But that reaches a certain point. And if there is then a point where the provincial law still frustrates that core federal purpose, that core federal jurisdiction, then paramountcy does kick in as the ultimate hammer. And that's what you've seen in linear infrastructure projects for years now, including the Burnaby case that you cited. It came up also in the Energy East context, in the Quebec pipeline context. And the law has been relatively clear that at the end of the day, if there is actually what's sometimes called an operational conflict, then paramountcy will kick in, and the federal law carries the day.
I want to get again examine your comments about ministers trying to keep this in the political realm of negotiation as opposed to constitutional rulings. And he did say that Ottawa would act, and this is Hodgson I'm talking about,
Sure.
that Ottawa would act as a constructive participant in conversations between Alberta and BC.
Right.
And that would seem to, I think, to support your argument that the government really would prefer that this be a negotiated issue as opposed to anybody, have a court rule on it, or for the federal government, to come in and exercise its jurisdiction.
Yeah, you're right. And I think what you're seeing there is a product of the stage of the legal process that we're at. And we're actually at more of a pre-stage. So the Building Canada Act only really kicks in when a capital P project is presented to the Major Projects Office. So we know that the first 5 projects were provided to the Major Projects Office, although it has since been suggested, or at least indicated, that the clock has not actually started ticking yet. So once that is in the hopper, if you will, then there's 30 days before cabinet can actually add it to Schedule 1, and it's in that period that you're looking for things like provincial consent, if applicable, some support or at least consultation of Indigenous communities, and so on. So we're actually still before all of that, which comes as a surprise to many of us. It looks like the MPO is in sort of a facilitative role to make sure that these really are at a point where that the 30-day clock ought to start ticking. And so I think that's why you see this stance from the federal minister and the federal government, that they're kind of in facilitative, interest-based negotiation mode, trying to make sure that everyone is more or less on the same page before that formal clock starts ticking, notwithstanding some of the constitutional and legislative interpretive issues that we chatted about.
Well, thank you, Dave, because this has been, I think, you've cleared up some of the confusion around what the federal government might be doing. Because my first instinct, and I said this in a video last week, was that Hodgson seems to not understand, the legislation and this settled law. But then, on the other hand, if in fact their strategy is to keep the parties at the table negotiating, and that was the purpose of his comments, then maybe we should be a little more
Yeah.
generous in terms of how we view his words.
Yeah, I mean, I'd be surprised if he chose not to get into conjecture too much, but I'd be surprised if those were not really intentional words. And I think it was recognition that we're at this pre-stage. The other thing to keep in mind, of course, is that Section 5 sub 6 of the Building Canada Act has these factors that the government will use when determining whether or not a project is of national interest. And there are 5 kind of high level, hard to interpret provisions, but what's clear across all of them is, it has to be in the best interest of all Canadians and so on. What's clear is that if a province who is going to actually encounter some of this project in real physical ways is not supportive, it's hard to satisfy those criteria. And those are threshold criteria. So I think what you're seeing from the federal government is trying to get the dialogue to a point where those factors are satisfied enough that then it can be formally presented to the Major Projects Office so that the clock can be ticking. And that's why I think you see this sort of coaching facilitative stance, knowing that they're within the shadow of constitutional law is cast upon them, they're within it. But we know from many painful years of litigation in major projects that it's better to try to clear this stuff, and more efficient, cheaper, and to try to clear this stuff early on so that you can basically contract into regulatory certainty rather than contract out of it in the form of litigation risk and protracted acrimony.
Dave, thank you very much for this. It's been very enlightening. Thanks a lot.
Well, it's always a pleasure. Thanks for having me, Marco.